So you're probably thinking, well, I got a lawsuit in the mail. Somebody came to my house and handed me some lawsuit papers, and I got formally served, or I got a letter in the mail from like another attorney that's saying that a lawsuit was recently filed against me, and I'm just trying to figure out what my options are. Well, the first thing you want to do is you make sure you get that lawsuit answered. Now, you have a short window of time to do that. If you're in Texas, if it's justice court, you have 14 days. If it's a state or district court, you have 20 days. And if you're in Florida, you also have 20 days. So my firm, what it does, it helps consumers throughout the state of Texas and Florida defend those debt lawsuits. So what you want to now know probably is what your options are. Well, the first thing is you have to file an answer with that lawsuit. So make sure you get that lawsuit filed, that answer filed, that lawsuit. Either you do it yourself and make sure you do it right. And if you hire a lawyer, make sure they will take care of that process for you. Make sure they meet that deadline. Now, what happens is if you're considering not filing an answer, this is what will happen. The thing is, let's say if you don't go out there to the court and you don't file that answer to that lawsuit, then you're going to get something against you called a default judgment. A default judgment is a judgment that means that you forfeited, you refuse to show up, and the debt collector, the bank, or the credit card company, they're going to get that a judgment against you for whatever amount of money they're asking for without you contesting it or fighting it. So that's what happens. Now you're probably thinking, well, let them get a default judgment. What's the worst thing that's going to happen? Let's say if the bank or the credit card company gets that default judgment against you, the next thing that happens is that they can send you what's called post-judgment discovery. Post-judgment discovery is going to be paperwork that's sent to you that's going to ask you for your assets, your employment information, your bank account information, where you keep your money, where your property is, what you own, what you don't own. So let's say you're thinking, well, I'm not going to even answer that. I'm not going to answer the post-judgment discovery. What's the worst thing that's going to happen? Well, the next thing that's going to happen is, if you don't answer that post-judgment discovery, the attorneys for the bank or the credit card company are going to go back to the judge and say, Your Honor, Mr. Jones has refused to answer the post-judgment discovery. We want to get an order from the court compelling him to do that. The judge is going to issue that order compelling you to answer that discovery or appear at a deposition. Now, a deposition is where they would have the attorney for the credit card company, the bank, or the debt collector, and they would go up against you, and they would put you in a room, or nowadays in Zoom, and what they will do is they're going to ask you questions about your assets, your financials, if you owe, all that stuff where you keep your money and what your property is. Now, if you don't answer the discovery or show up for the deposition after the judge compels you to do so, the court, in a lot of instances, what they do is they issue something called a contempt of court order. Now, that can result in imprisonment. You can go to jail for not complying with the court's order. So what you want to do is you want to avoid all that. Now, maybe you're thinking at the beginning of all this, like, what if I just don't get served and I can avoid this entire process? Well, the problem with that is that's not actually going to work out, because if you don't get served, the bank's attorneys, they just go back to the judge and they say, hey, well, Judge, Your Honor, we're trying to look for this person. He's evading service. This is the last known address. Let us go ahead and serve him in something called an alternative service. So they're going to either leave the papers at your doorstep, they're going to mail it to your last known address, or put it in a newspaper, or whatever manner the judge says is appropriate. Now, what happens at that point is the judge is going to say, well, the service is completed, it's good, and they'll get a default judgment against you. And all those things that I just mentioned happen right after that. So the best thing to do is, honestly, is just to get ahead of this. Now, if you bring in a skilled attorney that handles debt defense cases, there's a couple of things your attorney should look at, and that should be the actual the lawsuit itself. And was it drafted correctly? Did they have everything in there according to the law? Are they providing the number? Are they providing the account number? Are they providing the date it was charged off? The delinquency date? Are they putting the proper information in there? Are the documents that's supposed to be attached to the lawsuit, are they attached? And if they are, Are they complete? Are they not complete? All those things can create what's called objections. Okay. The next thing your attorney should look at is something called an arbitration clause. A lot of credit card agreements have an arbitration clause. Sometimes your attorney is able to force the case to be dismissed because of arbitration, or they can have the case dismissed because the documents weren't provided correctly when they filed a lawsuit, or the lawsuit itself was defective in some way. So those are a couple of things that a good debt defense attorney would know and would definitely look for. So the next thing is, let's say if the lawsuit's filed correctly, there's not an arbitration clause, it has to stay in court, what happens next? So at that point, if you're working with a flat fee attorney, what you want to know is this. Are they going to litigate this case? Are they going to fight this case to trial and see what happens at trial? Or are they just going to, from day one, reach out to the opposing attorneys and try to work out a settlement agreement for you with the bank or credit card company or the debt collector that's suing you? See, at our firm, we don't engage in settlement discussions. We don't recommend engaging in settlement discussions with the debt collection company, the credit card company, or the debt collector, debt buyer, because we want to actually litigate the case and see if they can prove up their documents. So that's our philosophy. That's what makes us different, is that we do it for a flat fee, but we like to fight our cases. We like to fight our cases, and we like to give them a hard time, and we like to get the documents before we advise our clients to make an offer of settlement, if they should make one at all. Because what happens is a lot of times those documents just aren't there. They're not sufficient. A lot of times those documents just cannot be admitted in court. They could have several issues with that. So we look at the rules of evidence, we look at the documents, we look at the lawsuit, and if there's any particular reason for those documents not to be admitted to court, we can get the case thrown out and dismissed against you, and that is the end of the story for that lawsuit. So if you're looking, another angle that we look at is if there is a possibility that they filed a lawsuit incorrectly, sued you in the wrong county, or sued you for the wrong amount. We also bring counterclaim lawsuits against them for violations of the Debt Collection Acts. So that's something we definitely always look at in these cases, and if that happens, we can also get a lot of circumstances in your situation may differ, but we can get the debts canceled and possibly get it off your credit report as well. So if you're interested, give my office a call. We'd be more than happy to work with you regarding your situation. And once again, my name is Sean Jaffer. I'm with the Sean Jaffer Law Firm. And if you need any further information, give us a call.